Okay, whenever you are ready.
Okay, it's 12 o'clock on the dot out here Pacific time. Welcome everybody to the 2020 California Legislative Update. We have a lot to cover, so for those who are just trickling on, you'll get the recording after the fact, and anything you missed, you can go back and see then. But we're going to start out with just the initial housekeeping items. Again, welcome. We are going to cover new challenges for employers. There's not as much this year as in prior years because, this year was crazy, and the legislature, just like everybody else in the United States and the world, has been affected by COVID's disruptions in business. The problem is that created some doozies of new laws. Even though there were fewer, they are some difficult ones, and they are some ones that you need to implement right away if you are an employer doing business in California. So while we have fewer total new laws, we've got some that have some pretty significant requirements that you need to get to your companies in gear to deal with right away. So we will jump right into those. Quick introductions. You can see everyone's smiling faces. We have with us today, I'm Christina Lonnie, based in Sacramento. I'm head of the California Labor and Employment Legislative Team, also a member of California Workplace Solutions. And we have Workplace Solutions members, Elizabeth Levy, Chelsea Mesa, Kobe Turner, and Sharday Scahan. And Sharday is also a member of our People Analytics team and is going to talk about the mini California EEO-1 bill. And all of the ladies with me are incredible counselors, and I'm so thrilled to have them today. So our next slide is a slide, if you've been on our webinars before, our legal disclaimer, we got to do it. This is for informational purposes only, not legal advice. There are smiling faces and, without our work from home backgrounds behind us. Here is our agenda for today. We're going to start with sick pay issues, go to Cal OSHA updates, workers' compensation, talk about AB5 and independent contractors, then some handbook updates, including some changes in the California Family Rights Act, the pay reporting, mini EEO-1, and board membership requirements will follow on to some legislation from last year. Then the miscellaneous new laws and some industry-specific bills. And then finally, while we probably won't have time to get to them, we'll talk about a couple of bills that Governor Newsom vetoed just because they are very likely to come back again next year. I'm going to plug it now. You'll probably hear it plugged throughout the presentation, and then we have a slide at the end. But all of these bills and more, including some in-depth updates, are on our California Peculiarities blog. So feel free to, go check that out and make sure you sign up if you are not already signed up to get updates through it. So with that, let's kick it off with some sick pay issues.
Thanks, Christina. So I think one of the hot topics that we have right now is AB 1867. It was signed September 9th. It came into effect immediately. Employers had 10 days until September 19th to start providing leave under this new law. This is designed to fill gaps between different state and local laws and the federal Families First Coronavirus Response Act. It does codify the food sector worker leave, which came out in an executive order a few months ago. I could spend an hour on this alone, but I won't. In a nutshell, employees are entitled to up to 80 hours of COVID-related leave for 3 specific purposes. To be eligible for the leave, they need to be leaving home to do work for the employer. Thorny issues may pop up if you have people that are leaving home, say, once a month to go check the mail. There are a lot of permutations there, something to be aware of and mindful of, and walk through exactly what your situation entails. But for employees that are entitled to this leave, they part-time employees, there are different calculations, different ways to determine what those folks are getting. There's a wage statement requirement that came into place. So these employees need to be told what their available bank is on either the wage statement or a separate writing similar to regular paid sick leave. But it's a bit complicated because some of the calculations are complicated. To be able to take this leave, the 3 covered reasons are essentially that they've been ordered to quarantine or self-isolate pursuant to some type of federal, state, local order. A healthcare provider has advised them to do so, or the third reason, that the company has prohibited them from working due to health concerns related to the transmission of COVID. So 3 specific reasons. Offsets are possible under certain circumstances. I've been fielding a lot of questions about that. It's possible, but be very careful is sort of the best way to explain it. This leave is designed to be a separate type of leave over and above regular paid sick leave, over and above regular vacation time. And not to one other area that employers are particularly concerned about is that there's a sort of mushy documentation process. You can't ask for documentation. There are some guidelines that, if you have questions, may be helpful. The DLSE has issued guidance that effectively says if you have an employee who you believe is falsifying information, it may be appropriate to ask for documentation in that circumstance, but you can't, as a general rule, you don't want to be requiring documentation in order to allow these employees to take leave. And I just to not have it get lost in the shuffle, there is a small employer family leave mediation pilot program that was part of this law. But if we move on to the next slide, I can just discuss some of these local leave issues and how they interplay with this new statewide leave. So the statewide leave provides sort of for offsets and for certain types of leave to run concurrently. And you have a lot of cities and counties that have enacted different types of local COVID related leaves. So if you have employees or facilities in these particular locations, you want to see what types of leaves they've taken and make sure that you're in compliance across the board. For an offset to apply, an example I like to give is if you have, for example, a Los Angeles employee who was, took leave because their child's school was closed. That's something that was available under Los Angeles leave. School closure is not a covered reason under state leave. So it's a pretty complicated law. And because it came into effect immediately, it is just something that you'll want to make sure that you're up to speed on, along with all of these local jurisdictions. And if we move on to the next slide. This is not as hot of a topic, but still important to note. AB 2017, it provides employees the sole discretion to designate days taken as paid sick leave under the labor code. So it is up to the employee how they want to handle those days of leave. I think we can move on to the next slide.
Great. And Elizabeth, before we move on, I think it is important because, we have so much to cover that we are flying through this to emphasize that this bill was really, really complicated. And by this bill, I mean this bill, 1867. And,
yes.
We have a whole team of counselors who have been, discussing all these complicated issues on an ongoing basis. So if clients read the bill and they're confused, it's for very good reason. And they can call any one of us, you, Elizabeth, Kobe, Chelsea, any one of our counselors, because we have had the brain trust hard at work trying to figure out the answers to some of these complicated questions.
Absolutely. And I will note with pretty much anything COVID related, guidance can and will change on you. So even in the short time since this has been enacted, I sort of caught it the other day as I was looking at the DLSE FAQs. They've changed, and not drastically, but they have updated them since that first go around. So it's important to just keep up to date and walk through these issues because this is an incredibly complicated law.
Great. All right, moving on to OSHA. Kobe, you're muted.
Thank you. I know it's going to do that at least once. Sorry about that. So everybody, I'm sure many of you are aware of this already. This is the new Cal OSHA reporting requirement. It was effective immediately upon the governor's signature earlier in last month. So basically what this requires is that employers within 1 business day of receiving notice of exposure to COVID in the workplace, that they have to provide written notice to all the employees and anyone else, like subcontracted employees, union reps, anything like that was present on the same work site. They need to provide them notice of the potential exposure in the workplace. One of the things that people have been asking about is like, what does it mean to be on the same work site. And that essentially we've been saying is a sort of the same airspace rule, because some employers may have multiple buildings, multiple fields, multiple campuses. And the notification requirement is basically like, have they come into contact with this person? If yes, you need to tell people about it. When the notice requirement is triggered, it means that you need to notify them about everything that related to COVID-19 benefits, including things like the workers' comp they might be eligible for, COVID-19 related leave, which Elizabeth just covered, as well as other company paid sick leave, state mandated, or other local laws that may apply to them. They also need to be notified about the disinfection and safety plans that the company plans to implement in accordance with the CDC guidelines and potentially local requirements, which may cover where your facility is located. Also, if there is an outbreak at your workplace, you need to notify the local public health department within 48 hours. An outbreak, you will notice as we go through a number of these laws, what an outbreak is defined differently under a number of these different laws. But here, an outbreak is currently, now let me tell you, this is changing, as Liz mentioned, depending on the California Department of Public Health definition at the time. But right now, an outbreak is 3 or more laboratory confirmed cases of COVID within a 2-week period among people from different households. And so if you become aware of an outbreak at the workplace, you need to let the local public health department know within 48 hours. Another big change from this bill has to do with Cal OSHA's ability to shut down a work site if they deem that it is an imminent hazard related to COVID-19 exposure. Previously, they had to give you a notice of an intent to issue a serious violation, and you could provide evidence to dispute that violation. Now, you don't get the chance to do that, and you don't get the chance to respond. They can just shut you down. So that is a big change as well. There are some slight exceptions to this bill, particularly related to the health industry and a few other specific types of industries. So if you have questions about industry specifics, please reach out to your favorite counselor. The next thing that we up on the COVID-19 OSHA situation is, this is pretty quick. It's OSHA related awareness. It basically just requires OSHA to issue information on best practices to employees in English and Spanish. It doesn't necessarily specifically require updates from employers, but we want to make sure you are aware of it, because this will be something that your employees should be getting awareness of. And you can go ahead and move on. Liz, you're on mute.
I knew I was going to do that at least once. Thank you. Thanks, Kobe. So another hot topic in the COVID related realm is SB 1159, which is sort of an extension of the executive order that relates to the workers' comp presumption. It also creates a new framework for a workers' presumption going forward. So as you may remember or recall, there was an executive order a few months ago. If you were performing work for your employer at the work site, tested positive for COVID within 14 days of working, there was a rebuttable presumption that you had contracted COVID on the job. And that executive order was set to sunset July 5th. Employers were left in the dark as to whether or how that would be extended. We got our answer September 17th. The governor signed this new law, and it went into effect immediately. So this one is particularly important. If you haven't taken an inventory to make sure that you're in compliance, you'll definitely want to do that. So what it does is it effectively codifies the previous executive order, and then from July 6th forward, it expands the presumption for most employers, where if you've got people who are the same 14-day testing positive, if you've been working at the worksite within 14-day requirement, but now it comes into play where there's been an outbreak. And as Kobe mentioned, an outbreak can mean different things. And here, it's a very specific definition. It is defined as if you've got fewer than 100 employees, you're looking at 4 employees or more. If you've got more than 100 employees, you're looking at 4% of your workforce. And there's also a reporting requirement that comes into play here. So employers need to make sure that they're informing their workers' comp carriers of positive cases. One key piece of this employers should be aware of is that a slice of this is retroactive. So if you've had positive cases between July 6th and September 17th, or really thereafter when it came into effect, you'll want to make sure that you go back and report that information to your workers' comp carrier in accordance with this. And there are some potential penalties that can come into play for failure to do so. And the law is set up so that the definition of outbreak will, I think, be determined based on these reports. That's why you're able to have sort of this more mechanical, over 100, less than 104% type of definition for outbreak. And I think we can move on to, and as I mentioned, before we move on, as I mentioned, there are some exceptions, for certain types of, firefighters, for example, there's some potential exemptions here. But most employers that are outside of sort of a first responder type of environment will have this come into play.
Great. So Elizabeth, before we move on, I was so excited for us to jump right in that I neglected to read some of the housekeeping items that I was tasked with reading. So, just remember, y'all are in listen-only mode if you haven't figured that out yet and started to yell questions at us. If you do have any questions throughout the program, you can please use the Q&A section located on the right side of your WebEx window. So if you've been holding those questions up in your brain, go ahead and spit them out now into the Q&A section, and we will try to get to them at the end. But as I said, we have a packed agenda, so if we don't, we do collect the questions, and we will, try our best to respond to each of you individually. But again, you can feel free to follow up with any of us individually after as well. Our information is on the slides that you will get after the presentation is done. For those of you who are interested in CLE credit, an attendance verification code will be read during the presentation. It will be near the end of the presentation, so y'all have to stick with us till the end and pay attention. But we will read it. Please write it down. It will not be repeated, and it is required for CLE credit. The CLE credit instructions for submission, the presentation recording, and the slide deck will be distributed to attendees in the days following the presentation. All right, so with that, let's talk about independent contractors. Kobe?
And I remembered to unmute it this time, so we're making progress. Okay, so everyone, many of you use independent contractors, but even for those of you that do not, this may still be relevant because it also may affect if you are doing contracts with businesses, which the businesses in and of themselves may be contractors or may employ contractors. So this has a broader reach than people may think. AB2257 is a follow-on bill to the previously passed bill last year called AB5, which many of you may be aware of. AB5 was in and of itself essentially a legislative codification of a decision that came out of the California Supreme Court in 2018 called Dynamics versus Superior Court. And that case said that a worker is a company's employee unless the company proves that the worker is free from control and direction of the hirer, both under the contract and in fact. The key one, which gets most people, is that the worker performs work outside of the usual course of the hiring entity's business. And then C, which is the worker customarily engages in an independently established trade or business in the same nature of the work performed. So, for example, you may traditionally think of an independent contractor as somebody like a plumber that you hire to come into your house and fix your pipes if something breaks, something like that. So the ABC test was codified in AB5, which came into effect in January 1st, 2020. It has not been that long since this law has been in effect, and it is such a mess that they have already granted a number of exceptions due to extensive lobbying by many industries, many of which were just recently codified by AB2257, which has substantially revised and clarified AB5. This was effective immediately upon the governor's signature last month. Christina, if you could move to the next slide, please. So some of the big changes from AB2257 are that it creates, it expands the reach of AB5 to provide for broader government enforcement. So previously, it only allowed the Attorney General and city attorneys to file injunctive relief actions, which you may have seen in the news recently against a number of gig companies. But now it also allows district attorneys to jump on that bandwagon in an effort to enforce the law more vigorously. It also expanded it expanded the number of exemptions to include additional industries, and those and it's looking like maybe a slide came out of the presentation, so we are going to have to insert something back in. So it included a number of additional industry exemptions for expanding the exemptions related to reporters, a number of additional creative industries, such as those in the music industry and things like that. So if you are in an industry-specific situation, you should reach out to your counselor to see if any of the additional industries may have reached your fellows. But some of the biggest changes that are concerns for a number of our clients in particular are the expansion and clarification of the business-to-business exemption, which has changed to change the nature of the way that if you contract with a business, which in and of itself employs independent contractors, that it is assumed, for instance, that this test only applies if someone is engaged as an independent contractor by at least one of the two parties. So the big question that remains for a number of our clients is if you contract with an entity which in and of itself hires independent contractors, does this test now apply to you? And that is still an open question. So that's something to proceed with caution. There are a number of industries that attempted to get additional exemptions with AB 2257, which did not make the cut, including the gig economy companies, the franchising industry, the trucking industry, and the motion and picture and television industries, which are still jumping at the bit to create additional exemptions, which have been pending before the legislature and are continuing to work their way through. So in terms of what's next, many of you have seen that Proposition 22 is still on the ballot right now. I'm trying to get what we would call a third wave for the gig company industry rather than employment or independent contractor. It sort of provides many of the benefits of employment without actually categorizing people as an employee. If that works, we expect many other industries will try and proceed with something similar. And a number of other industries are also lobbying for exemptions at this point. And we can move on from there to Chelsea.
All righty, Seyfarth handbook updates. Chelsea.
Thank you. Thanks so much for having me. As someone whose favorite topic is employee handbooks, you can imagine I don't get invited many places. So I do want to talk briefly about a few bills that were passed that do have handbook related implications. And if we want to start with the California Family Rights Act, and by extension, its amendment, last year, the New Parent Leave Act, you may recall, of course, that California has a version of the FMLA and has had one for many, many years. And the two laws do largely overlap with a few limited exceptions, like with pregnancy disability leaves. And then last year, the legislature amended SIFRA to drop the threshold number of employees for parental leave only and created a requirement for protected leave for smaller employees or employers, those with as few as 20 employees within a certain mileage threshold. But this year's update, again, reduces that threshold for all SIFRA leaves down to 5 employees and essentially eliminates the NPLA as of January 1 and also eliminates that mileage threshold. So we no longer need to have X number of employees within a certain number of miles. That is gone. That means that employers with as few as 5 employees are now covered under SIFRA. So if you are a smaller employer, you will need a written policy, as SIFRA has a written policy requirement. And for employers who have always been covered by SIFRA, you are not off the hook. You will need to update your policies as well due to some other amendments, which we will talk about. So on the next slide, we will see that this amendment also expands the definition of covered family members for purposes of family care leave, essentially meshing it with the definition we're already using under PFL, FTDI. So it now includes leave for caring for siblings, grandparents, domestic partners, and removing the disability and age requirements in the definition of child. So that's actually really important too. Also eliminating key employee exceptions. I know that a lot of people didn't take advantage of those, but it's important to note that that doesn't exist under SIFRA. And it's adding as a new reason for use a qualifying exigency, very similar to how it is addressed under FMLA. So, clearly the largest impacts here is that it's creating additional reasons for use, and several of them are not also covered by FMLA. And so that means there are going to be additional times that FMLA and SIFRA are not going to run concurrently, and that could result in an entitlement to additional time off for employees. So we strongly recommend that these updates be reflected in your new policy for 2021. Make sure you get in touch with your favorite advisor on this one. We want to get those handbooks updated in plenty of time. On our next slide and our second handbook related bill, it's AB 2364, which is a judiciary omnibus bill. It's a fancy way of saying a large bill that addresses a bunch of stuff that have nothing to do with each other. But for our purposes today, this one addresses the military and veteran status under the California Fair Employment and Housing Act. The previous language and really the title of the protected status was military and veteran status. And this essentially replaces the and with an or, makes it more accurate, makes it make a little bit more sense. And it's important for purposes of handbooks, because I'm sure, as you recall from my very compelling lecture on this topic in 2016, a written handbook policy is required for harassment and discrimination in California. And the regulations require that that policy include all protected statuses under FEHA. So if your policy currently says military and veteran status, we need to correct that to replace that and with an or. And that is effective as well as January 1, 2021. Our next slides and our third and fourth bills that we're going to be talking about today have handbook implications, but not because they have written policy requirements. We do find that employers have policies on this topic. It's pretty common. So we want to ensure you know how they should be updated in case you fall into the category of an employer who happens to have one. So first is AB 2992, which is amending, as you can see, Labor Code Section 230 and 230.1 related to leaves and accommodations for employees who are victims of domestic violence, sexual assault, and stalking. This bill essentially accomplishes two things. It's going to expand the prohibition on discrimination or retaliation against employees for taking time off who are victims of domestic violence, sexual assault, stalking, and also include other crimes and abuses that caused physical injury or that caused mental injury and a threat of physical injury. And it also expands it to include a person whose immediate family member is deceased as the direct result of the crime. The second change, it's changing the definition of crime as a crime or public offense as set forth in a government code section, and regardless of whether the person is actually arrested, prosecuted, or convicted of committing the crime. So really broadening that definition of crime. And as I mentioned, there is not currently a written policy requirement for domestic violence related leaves. But if you have a policy on that, we recommend reviewing that policy to ensure that your language is not inconsistent with these updates, and also recognizing that there is a onboarding pamphlet that relates to domestic violence leave. And so you should expect that the DLSC will update the pamphlet. And so look for that for purposes of getting your onboarding paperwork in good order for 21 hires. Lastly, our fourth bill, which is AB 2399. This one is actually creating a new covered reason for which employees can apply for and receive paid family leave benefits from the state, essentially for qualifying exigencies. This is in line with the new covered reason under SIFRA, and it does add or amend definitions and documentation requirements to align with this new covered reason. So we're essentially expanding PFL to add another reason why people can get benefits. Now, again, isn't an area where an employer is required to have a written policy. I do see a lot of PFL policies in handbooks. And so, of course, if you have one, make sure that your policy does reflect this change. So if you need to spruce up, obviously, this is one of those things that you should be addressing. And also, again, another onboarding pamphlet, another onboarding requirement that we should be looking for an updated pamphlet that's going to address this new change if it hasn't been, I didn't check today, but if it hasn't been published already, expect that there will be a new PFL pamphlet that will be made available because we do have a new covered reason. So anytime somebody's onboarding or taking a leave that could be covered by PFL, you want to make sure you have the updated 2021 version of that pamphlet to give to your employees when they need it. So with that, it is time for the most exciting part of the day, the CLE code. Grab your pens. It is SS as in Seyfarth Shaw 8120. That is SS 8120. Okay, so now I will turn it over to Sharday Scahan for her expertise on a few of these bills.
Hey everyone. So there is huge news this year in the pay equity space, and that's California's inaction of SB 973. This has been going through the legislature for the last few years, and this year it finally passed. It's going to apply to private employers that have 100 or more employees. That's kind of a big issue right now. That's a huge question of how are they defining the 100 or more employees, because right now the law is a little bit vague. So we're still waiting on clarification as to whether that's going to be 100 or more employees in California or all of the company's employees. We expect the DFEH is going to release some sort of guidance. Perhaps the DLSE will release some as well, but we think that they'll have some kind of FAQs or guidance before the first reporting deadline comes up in March. So the first report is going to be due by March 31st, 2021, and then each year thereafter, you are going to have to submit your report by on or before March 31st of that year. And the report's going to need to include the number of employees by race, ethnicity, and sex, and those are all going to be categorized by the categories set forth by this law, which you can see up on your screen here. You also have to include the previous year W-2 earnings and hours worked for all employees. Again, that's kind of a gray area right now as far as how that's going to be calculated, because it's a little bit different than what we saw with the EEO report. So again, we expect to have some sort of guidance on that as well coming out in the FAQs. We know for a fact that the DFEH is working on their site right now to submit everything, so we anticipate something else will be happening there as well. And the bill itself does direct the DFEH and DLSE to adopt procedures to enforce this new section, so that's why we're anticipating they're going to have some sort of guidance coming out to help us nail down the particulars of the pay reporting law. Like we said, it's brand new. It was just signed by the governor a couple of weeks ago, so I think that's kind of all in motion at this point. For your pay report, it's going to be based upon a snapshot period that can be anywhere from October 1st through December 31st. So for your pay report that you're going to submit next year, essentially that snapshot period could already be happening right now. It's going to be based on your workforce at the end of any pay period between that time. So that started October 1st and goes through December 31st. Another note about the pay report is that it needs to be submitted in a searchable and sortable format. Again, trying to figure out exactly what the DFEH is going to be looking for. They're not quite sure yet since they're putting together all of the rules right now, and they're currently working on kind of the best way to submit this information. So we expect to get something more on the exact format that it can be submitted once they release their guidance, because we know that they're putting that together at the moment. The DFEH also now has authority to seek an order requiring any employers who did not comply with this pay reporting law to comply. And so it's very important that everyone makes sure that they are on top of things. They meet that March 31st deadline. And the DFEH is required to make those reports that are submitted available to the DLSE and keep that information for at least 10 years. So this is going to be a lot of historical data that they're collecting by these pay reports being submitted. There's definitely some holes in this law, a few questions that we're waiting to be answered, and we expect those FAQs to be helpful to provide additional information and clarification on anything that is missing at this point. But a challenge with this law is, as you know, the groupings can be very, very broad for this because, for example, it requests all levels of managers. So there can be a lot of different levels of managers, and they can have a broad variety of work that they do. So there's no requirement that their work be substantially similar. There's no language like that in the law. So essentially, it's going to be potentially categorizing a number of different types of employees into one category, and their jobs may not be similar such that we would ordinarily be categorizing them together. So that's just something to kind of be aware of and watch out for moving forward as companies and employers start creating their pay reports and submitting those to the DFEH. Okay, so now we can move on to Board of Director diversity. This is similar to a law that was previously passed that was requiring diversity for genders of boards. And so this is more based on underrepresented communities. It's very, very similar to SB 826, which was the bill that was requiring gender diversity. But note that the numbers of directors and the number of required board members are going to be different. So for AB 979, which is requiring underrepresented communities to be represented on boards, if you have 9 or more directors on the board, it's going to be 3 people at least required. If you have between 5 and 8 directors, that will be 2. And if you have between 1 and 4, that will be 1. Those numbers are different than the female board membership. So don't look at the numbers for female board membership and assume it's going to be the same because you'll be out of compliance with this law. So make sure that you're following this table that we have up here explaining how many board members you need from underrepresented communities. The definition of underrepresented communities is actually pretty broad. As you can see on the slide, they identify, of course, lots of different ethnicities that will be considered an underrepresented community, but it also identifies gay, lesbian, bisexual, or transgender board members as well. So it can be any of the ethnicities listed, or it can be anyone who fits any of those categories. So that's something to keep in mind as well when you're reviewing your board membership and trying to determine if you're in compliance or if any changes need to be made to the composition of your board. The fines for violating the statute can be pretty steep. As you can see, it can be $100,000 for the violation and then $300,000 for each subsequent violation. So that could really add up even if you are just out of compliance by 1 board member. So it's very important to start reviewing your board membership and identifying any changes that need to be made. And again, you can talk to any of the people presenting today and can help walk you through some of the potential options to make sure you are in compliance both with the statute and then also getting your pay report together and start identifying categories of employees and how that is going to look for your company.
Awesome. Thanks, Sade. So let's move on to now our miscellaneous pieces of legislation. Elizabeth, let's dive in with settlement agreement changes yet again, every year it seems.
Yeah, this is another year. This AB 2143 sort of piggybacks on last year's 749, which essentially prohibited no rehire clauses in settlement agreements. So as this notes, existing law, which is the 749 from last year, prohibits the no hire provisions in settlement agreements unless, and under very limited circumstances, the employer had determined in good faith that the aggrieved person engaged in sexual harassment or sexual assault. So what this does is it gives employers, in some sense, a little bit more breathing room. This new law revises that section of the labor code require that the employee has filed their claim in good faith for the prohibition to apply, and the employer has to have documented the determination of sexual assault or sexual harassment. And it also expands the exception so that if there's been a determination that the aggrieved person engaged in any kind of criminal conduct, this is the type of thing that may not come up very often. But if you're settling something with a former employee or current employee that where there have been issues relating to sexual harassment, sexual assault, or potential criminal conduct, you'll definitely want to make sure that you've got the right provisions in your settlement agreement. You know, a one-size-fits-all template is just not always the best approach. So this is just an example of that. And one more piece of the puzzle that makes California settlement agreements a little bit tricky, especially in certain circumstances.
Yeah, and that's a very good point, Elizabeth, right? Because we have, you know, a lot of companies that like to have their template settlement agreement that would apply in all jurisdictions. But, you know, as of really the past 2 years, California has some very specific requirements now. So the one size fits all, unless you're sure it complies with all the California requirements, is going to be very dangerous.
Yeah, absolutely.
All right. What about the labor commissioner?
Labor commissioner. So this gives employees a little bit of a break. So AB 1947 here amends section 98.7 of the labor code, gives employees a little bit more time to file complaints with the labor commissioner. It also amends section 1102.5 of the labor code, which is essentially whistleblower actions, to authorize courts to award reasonable attorney's fees. Critics of this pointed out that this would sort of disincentivize you know, different types of basically that it would incentivize litigation over whistleblower claims, and it was actually vetoed previously, but this go around it slid through. So this is I guess a win for employees here. This is just something else.
And their attorneys.
Yeah, and their attorneys. So something else to keep in mind with these types of actions. You know, I'm sure plaintiffs' counsel will take note. And so we've also got AB 3075. This is sort of interesting. So there, when you're making certain disclosures, you'll need to report whether directors, officers have any kind of, and some other types of folks whether they have outstanding DLSE judgments. And there's some real implications for failure to accurately report that information. And this really is important for businesses who are taking over other businesses. So it includes some requirements and specifications where a successor is going to be liable for wages, damages, penalties for a company that they're taking over under certain circumstances. It sets forth specific criteria to establish successorship. So things like, you know, having the same facilities, having the same workforce. If you're acquiring anybody, you will just want to make note of this and make sure that you're doing whatever you need to do on this front. I think this goes into effect January 1st. It's not one of the immediate ones. And moving on to the next slide, this is interesting. This will really only impact employers going to trial, and it's not going into effect for civil cases until 2026, which seems like, I think, a lifetime away for most of us probably at this point. But it's pretty interesting, and it's designed to eliminate bias in peremptory challenges when you're selecting a jury. So essentially there's about a dozen different categories of reasons that are going to be for peremptory challenge that are going to be subject to heightened scrutiny. This is just something, you know, for folks like me who just find this stuff interesting. It's just a pretty interesting thing that you don't need to look out for just yet, but something to keep in mind. And I think even though it doesn't come into effect right away, I think, you know, courts may be mindful of it, and you know, you may be subject to a little bit of additional scrutiny with peremptory challenges if you find yourself going to trial. And this next one here, we have AB 1963. This is pretty important for employers who employ minors. So what this does is it expands the list of mandated reporters to include human resources employees. It's going to apply effectively a FEHA applies if you've got more than 5 employees. And the human resources employees here are defined as the people who are designated to receive complaints of misconduct. So you'll want to make sure that you're properly identifying who these human resources folks are. It also has provisions that impact people who directly supervise minors. And these folks that are impacted by this will need to get mandatory training on the identification and reporting of child abuse and neglect. This goes into effect January 1st. So something to be mindful of as you're double checking all of your policies going forward into the new year.
And especially so, Elizabeth, right? Because, as employment lawyers, and maybe part of the reason why we became employment lawyers is because we don't want anything to do with the penal code.
Yeah.
And, so we usually don't check in codes that are outside of the labor code, the government code, et cetera. So it's very important to remember that even though this sits in the penal code, this is something to which, a lot of companies and human resources employees are going to need to pay attention.
Yeah, absolutely.
All right, industry-specific legislation, entertainment industry, the folks who are getting us through, COVID quarantine.
Yes, we're trying to anyway. So again, this is another one that's specific to people that employ minors. So if you are in the entertainment industry and employ minors, and it's a relatively minor change, it basically just says that because you've had to be giving these people sexual harassment training thus far, but now it requires that a parent or legal guardian accompany the age-eligible minor, and that the parent or guardian also provides certification to the labor commissioner that training has been completed. The training that is required has to do with the sexual harassment prevention, retaliation, and reporting resources in case that the minor is subjected to sexual harassment. And then moving on from there, this is one that probably is going to be of more interest to a number of folks, which is has to do with rest period laws. So for most of you, I'm sure, are familiar that in the state of California, you have to provide employees with a 10-minute rest period for every 4 hours worked or major fraction thereof. So, anything over 2 hours, they need to be provided a paid 10-minute on off-duty rest period where they can't be interrupted. You can't require them to carry a communication device, etc. So this has been really difficult in a number of industries, particularly in industry, for example, like security guards. So security officers have been lobbying for an exemption from the rest break law, which is 226.7, for a number of years, and recently got one. So this is only currently in effect until January 1st of 2027 and does not apply to existing cases. So if somebody manages to file a lawsuit before January 1st of this year, they could still, in theory, get in under the wire. But the way that this changes the existing law is that it allows certain employers, private patrol operator employers, so if you're registered under the Private Security Services Act and they're registered security officers, it allows you to exempt them from some parts of this rest break requirement, and it allows you to require them to remain on premises during the rest period, to remain on call. So that means that you can have them carry like a pager or a cell phone, and to respond to emergencies if necessary. So this is crucial for something like security guards, and you do have to allow them to restart a rest period ASAP if for some reason they're interrupted. So if they get a call out on an emergency while they're on their rest period, they have to be able to restart it and take a full 10 minutes afterward. And if for some reason they miss a rest period entirely, such as an emergency is ongoing, they need to be paid an hour penalty pay at their regular base rate. This is interesting because what you have to pay penalties for with respect to missed rest breaks right now is on appeal and is pending before the California Supreme Court. This law specifically says that the penalty only has to be paid at the base rate as opposed to the employee's regular rate of pay. However, this slight exemption to the rest break law only applies to security officers that are covered by CBAs that otherwise cover working conditions as well. This is kind of significant because the discussion in the legislature related to this law had to do with the legislature's recognition that the nature and the job duties of these people made it necessary that they basically had to be on call during their rest breaks, and that it was important for them to be able to respond without any kind of delay. So we see this passage is actually kind of encouraging for employers in other industries that might be wanting to lobby for certain other similar exemptions. Right now, this is only rest periods also, but conceivably employers may be seeking to get similar exemptions for meal or recovery periods where they're also concerned about employees being able to remain on call. So this could pave the way for some other industries or similar professions to move for exemptions from the rest period laws. And we can go ahead and move on from here. This is another industry-specific exemption, very similar to the security officers one, but specifically related to petroleum workers. There is currently a rest break exemption on the books for these folks, but this extends the current rest break exemption, which was about to expire. Like the security officer exemption, it only applies to people that are covered by certain CBAs. However, this one is different, and it requires any sort of penalty for a missed rest break to be paid at the employee's regular rate. So if you are subject to one of these specific exemptions, make sure that you are dealing with that little anomaly shortly, or that you're dealing with that little anomaly specifically. This is another, moving on to AB 2588, I'm sorry. This is another industry-specific exemption that relates to people in the direct patient care industry, so people that are working at hospitals. And it has to do with expense reimbursement laws. So currently, the state of the law, as I'm sure most of you know, is that if an employee incurs expenses as a result of their employment, that those expenses need to be reimbursed by the employer if they're reasonably necessary and related to the job. So this was declared to be clarification and declaratory of existing law. So even though it doesn't technically go into effect until January 1st, you can assume that it's going to apply retroactively because they're claiming it's not a change to the existing state of the law. However, many healthcare employers don't view it that way and do in fact believe that this is quite a change to the existing law, and it requires employers now to reimburse employees for the cost of any employer provided or employer required educational program or training. So for example, it includes things like residencies, orientations, competency validations. Importantly, it does not include requirements for your license or registration necessary to practice. And it also prohibits employment contracts requiring that training costs be paid back if an employee leaves. And that is where, for most people, it's become it's more of a specific issue because in a number of healthcare settings, employers provide that they will provide certain special certifications, for example, special certifications related to gerontological specialties, CPR, things like that, that would be transferable certificates. And a number of employers require that if they pay for if they provide and pay for the training to be conducted for the employees, that the employee has to, for example, stay for a period of time and pay it back if they leave, things like that. Those are now prohibited under this clarification of the existing law. So if something like this applies to you and you have any questions, definitely let us know.
All right. Thank you, Kobe. Well, we were so nervous about, not having enough time to get to everything for you that we did a speed round, and we're actually going to get to talk about the two veto bills. I'm always super excited about the veto bills for various reasons, obviously, depending on what the bill is that's being vetoed. I know that this first bill, a lot of our clients or a lot of companies were excited with vetoed because there were a lot of ambiguities in it. So, we mentioned these vetoed bills because a lot of companies think, uh-oh, what about that bill that was pending? Do we have to comply with it? And we're here to say, at least as to these two bills we're going to talk about. And then there were others that didn't make it through the process, didn't even make it to the governor's desk. We're not going to talk about those today, but they are in our blogs from throughout the legislative session. So if you think there's a bill that we haven't discussed, but that you need to be worried about, either go back and look at our blogs or feel free to reach out to any of us and we can look it up for you and hopefully say, didn't make it through the session, you don't need to worry about it. This bill, AB 2216, it would have required certain employers, and they were specifically, although the definitions were even more convoluted, essentially hotel, private club, event center, airport hospitality operation, and airport service provider. What the heck does that mean? Read the bill. We weren't entirely sure either. It was up for debate. So again, glad it didn't make it through. But those employers would have had to offer employees who were laid off due to a state of emergency job protections, job positions that become available and for which the laid off employees are qualified. And the offers would have been based on a preference system and in accordance with certain timelines and certain procedures. It would have also required successor employers to give hiring preference to the employees. So, it was a well-intentioned law, right? Hospitality, airports were some of the hardest hit by the COVID pandemic, and a lot of employees lost their jobs as a result. And Governor Newsom recognized that in his veto message, but he said that, the real problem that this bill is trying to fix is ensuring that workers who have been laid off due to the COVID pandemic have certainty about their rehiring and job security. But the problem was that the bill's provisions relating to a state of emergency could create a confusing patchwork of requirements in different counties at different times. So he encouraged the legislature to consider other approaches that would be more practical and not ensure that workers were left behind, or rather ensure that workers are not left behind. The other
Christina?
veto, yes.
I just want to pipe in really briefly and say that in the COVID landscape, as always, be careful. There are local issues in play. So while the statewide law didn't make it through, be careful, check your county, check your city, make sure there's not something else that applies.
Yeah, very, very good point. And that's exactly why, or one of the reasons why the governor vetoed this, is because there is this patchwork in place. But that statement, Elizabeth, is a great reminder because, and it's a great bookend. You started this presentation with, our paid sick leave laws. And it's just a constant reminder that, sometimes the state is adopting something that is overarching, but even if it's intended to encompass, all of the requirements and be guidance to the entire state, there's even some specific requirements that the locality specific provisions have that the statewide law might not. So you always need to be very careful with the local laws as well. And, they're constantly changing just to keep y'all on your toes. So very good point on that one. The SB 1102 here, this would have required that the notice that, y'all have to provide to employees at the start of employment contain certain information regarding the existence of either a federal or a state emergency or disaster declaration issued within 30 days prior to the employee's first day of employment that may affect the health and safety during the employee's employment. And that was something that would have been of general applicability, but really the whole purpose behind this law was to help agricultural and farm workers. And the other part of this bill really was specific to farm workers and foreign agricultural workers. As you can see here on the slide, a lot of you are not agricultural workers, so we won't go into it. But what the governor did, instead, he directed the Labor and Workforce Development Agency to develop and maintain a template such as what was contemplated in the bill to make available to H-2A employers. The takeaway is, if you hear a rumor about needing to change the notice that you provide at the start of employment for this purpose, for the existence of a federal or state emergency or disaster declaration, you don't need to change it for that purpose. You do need to make changes to wage statements and notices in accordance with some other changes in the law, but not this one this year. So we have 3 minutes left. In those 3 minutes, you can take a look at our slide here that has where you can request a copy of our California Peculiarities ebook, where we have all of the developments like this, obviously not with these developments yet because they're brand new, but any of these new developments you can check on our CalPEX blog, on our mailing list. You'll get immediate notifications of them. Elizabeth, Kobe, Chelsea, Sharday, did you see any questions come through that we might want to hit in the last couple minutes?
Yeah, and maybe I'll let Liz chime in because I saw a huge number of questions related to the sick pay thing that I've been trying to sort of spot check and answer as we've gone along. But some of the big ones were, yes, it only applies to people with over 500 employees nationally. So if you are not covered by the FFCRA, then you are in fact covered by the California Supplemental Paid Sick Leave, subject to certain particular industry exemptions and that sort of thing. It is very complicated if you have employees that have intermittent or irregular schedules, and it's too much to go through in detail here as to what you would need to put on the pay stub for those folks. So we'll have to answer that question offline, because what you put on the pay stub for them may change because they are entitled to the number of hours worked over a certain specific time period as part of their supplemental paid sick leave. And they are also entitled to their 100% of their pay at the regular rate from the pay period prior to the one in which they took the leave. So that's different than normal California state paid sick leave, which is the pay period in which they take the leave. This one's the pay period prior. So that's a change from normal California state paid sick leave. And I don't know if, Elizabeth, if you saw a handful of others that were popping up repeatedly.
Yeah, I did. I noticed those questions. I think there were some questions about requiring people to take some other type of leave before the sick leave, and this is really, it's up to the employee. It's their discretion, so you can't require them to say, for example, use their vacation days or use a different type of regular sick leave available. If they're covered and they need the leave for a covered reason, then they're entitled to take it. The calculations are really confusing. If you have somebody who's full-time or that you categorize as full-time, I think some employers might consider someone full-time even if they're only working 38 hours a week. If you've got people who are categorized as full-time or who are full-time or working 40 hours a week or more, the calculations are fairly straightforward. And even for part-time folks, if they've got a set schedule, it's fairly straightforward. But for the people that are part-time and variable, it gets complicated. There are sort of potential things that you can do to sort of be overly generous. Or pros and cons to that approach. It is really truly a complicated law. And I will say that we have on the CalPEX blog, we do have an article that goes through this, as we do with some of the other big heavy hitters. I know we've got pieces on 685 and the new notice requirement that'll go into effect in January, the 1159, the EEO, the reporting. And Chelsea, I am so sorry. I can't remember. We've had so many blog posts and so many new laws coming out. If there's not something on the CFR expansion, outside of the legislative update, I'm sure that we'll have some materials ready to go and able to answer questions on that. But
yeah, I don't think that we do, but obviously we're happy to answer questions on that piece. I actually had a question pop up that I wanted to address too. So when you're done, Liz, give me a second and I'll address that.
Yeah, I just wanted to. We're slightly over time, so one more each, and then we've got to wrap it up.
Yeah.
Go ahead.
Oh, sure. I just wanted to mention because of the change in 230 and 230.1, that does impact the definition of what people can take sick time for under California law. Because remember, you're taking sick time, you can take it for domestic violence related reasons, and so there is a subtle tweak that does need to be made in your sick time policy if you lay out the reasons why somebody can take sick time under California law and go into the details about domestic violence, sexual assault, and stalking leave. And so I wanted to highlight that because it was raised as a question. So that's all. Thank you.
You ladies were so respectful. I felt like a debate moderator there for a minute, and you all just fell right in line. Elizabeth, did you have one final closing comment you wanted to make as well before we wrap?
My closing comment is I appreciate the questions. I wish we could answer them all to the extent that they're not answered on the blogs that we have already published. Obviously, you know, happy to try to answer these questions for folks offline.
All righty, awesome. Well, thank you all so much for joining us. Again, feel free to reach out to any of us with any questions. And again, you will get a copy of the slides and the recording within the next couple days. So thank you again for joining us and have a wonderful afternoon.